So we have this issue of standing. When we bring a lawsuit in federal court, the federal judges are always looking to say, do you have standing? Do you have an injury? Is there something that sort of opens the door to the federal courthouse? And if you don't have that, they kick you out. So while it's not the most exciting subject to deal with this idea of standing, this is an important case from about a year ago, the 11th Circuit. It's what's called a do not publish case, so an unpublished opinion. So it is not binding on the courts in Alabama, Georgia, Florida, federal courts. And it's not binding on the 11th Circuit, but it gives us some really good insight. And this will teach us the concept of when we bring a lawsuit, talking about not only the emotional distress that we've suffered, but the wasting of time. That can be critical to show that we have standing. Now, if you follow my approach, which is we bring everything in state court, the defendant that removes the case to federal court, they have to prove standing, because I didn't knock on the door of the federal courthouse. The defendant did. But even so, we still want to make it clear that we have standing, because we don't want to get, 90% of the way through a federal case and then the defendant gets the case kicked back to state court. Now some of this we have to start over. So we have had that happen before where unsuccessfully, but where we get right up to trial and then they try and get it kicked out for standing. And so just to delay and sort of jam us up. It didn't work, but it's annoying. So this will teach us an important lesson about how to properly plead or draft a lawsuit to help prevent this problem of having a standing issue. So my name is John Watts. I'm a consumer protection lawyer, and a large part of my practice is suing debt collectors under the FDCPA. That's what this case is about, under the FDCPA, Fair Debt Collection Practices Act, as well as under the FCRA, so Fair Credit Reporting Act. So let's see what we've got here. We've got a monthly fee to a condo association. It goes to a law firm. Law firm threatens to put a lien, and then I think they actually did put the lien. And so the consumer says, hey, I think this amount you're claiming is too much. And so he gets with an accountant, he gets with an attorney, and they realize, yes, the amount was overstated. And then ultimately they have to file a lawsuit. And so they settle with the association, and then the remaining defendants, basically the collection lawyers, say, hey, judge, you should throw the case out for lack of jurisdiction. And what they mean specifically is a lack of standing. And the district court agreed and threw it out. And so the consumer appeals it up to the 11th Circuit, which is the federal appellate court, over the federal courts in Alabama, Georgia, Florida. And that's where we get this opinion. So district court determined that the consumer lacked standing because the actions had not caused him any concrete injury. And the court says, well, our precedents, that just means the binding opinions that this court has written, have made clear the harm that the consumer described, including time wasted, can be sufficiently concrete and also emotional distress. And so they say the wasted time and emotional distress were adequate to satisfy the constitutional requirement for standing. And so the judgment is vacated or done away with, and it's sent back to that same district court judge to say, carry on with this case. And they point out, we don't have any opinion about whether the consumer should win or not. We're just saying the consumer has alleged enough for standing. So it's known as Article 3. And so as I'm recording this, we've been sort of in the middle of this potential debt ceiling crisis. And some people say President Biden should use this provision from the 14th Amendment. Well, this is from the Constitution. It just happens to be Article 3. And it talks about we have to have a controversy or case. And that's been interpreted to mean we have to have standing. So here's what the U.S. Supreme Court said in 2008, must demonstrate standing for each claim he seeks to press and for each form of relief that's sought. And so we have count one. So when we do a lawsuit, typically we say count one is this violation. Count two is this other violation. So count one is the notice of intent to file a claim of lien, overstating the amount, threatening to file it. And then, let's see, we come to count 2, and they did the same thing. And, it's slightly different, not important for our purposes. And then they actually did file a lien. And so he says, for all these claims, it caused him to suffer emotional distress, cost him time, money, and effort to determine, verify, dispute the amounts. And so in the deposition testimony and in an affidavit, he provides additional information and talks about like, hey, I made an extra trip. I spent some time doing this. And here's a little footnote. It gets a little detailed, but this is what's called a factual challenge to a lack of standing. There's what's called a facial challenge, which says, let's just look at what you say in the complaint. But a factual challenge is, let's look at evidence. And so it's a more detailed standard for both sides here. And so that's why the judge can look at affidavits, which are sworn statements, deposition where you're questioned under oath. And so going back to kind of the facts here, received letter notifying claim a lien had been filed. He recognized this was serious. He didn't want to lose his house to foreclosure. They wouldn't give him any information. This is pretty typical of these homeowner association law firms. They're just really pretty ridiculous to deal with. And so he's worried he'd lose his house and what would happen. And so he gets a lawyer. And part of the reason to get a lawyer is to determine whether the amounts sought were correct, whether there's legal basis, what's consequence, how much was owed. And so, he took time away from work and personal life. He had confusion, had emotional distress. And so here's the significant part. The district court, the trial judge said, you know what, your emotional injuries were insubstantial and it didn't really matter. And you wasting time is not enough. And your fees and costs in bringing the lawsuit can't provide the standing. Okay. And then you have what's called an informational injury without adverse consequences. So that's no good. And the risk of harm dissipated because this is sort of weird. This is an argument that's made, and this judge happened to buy it. But because the consumer knew that the letters misstated the amount and the collection firm had been fired by the association, so you should have known. There's like no big deal. It's sort of like we've had defendants that, let's say they sue our client, they lose, then they sue our client again, and then we sue them, and they go, well, you should have known that we had no basis to file that second lawsuit. You should have known it was impossible for us to win. Of course, it kind of makes you wonder, like, well, if my client's supposed to know that, why wouldn't you, a huge debt collector, know that? But, they say, well, we're just too busy. We can't be expected to know anything. So let's go back here. So this is what the judge threw everything out. And so they say, we reviewed this, what's called de novo. It just means they don't care what the trial judge did. They're going to look at it on their own. Now, if this was two witnesses contradicting each other and the judge decided who was telling the truth, then that would be a different standard. So here we go. Article 3 limits our jurisdiction to cases or controversies. And so Article 3 standing, we have to have injury in fact. So the defendant caused an injury and we can trace it to the defendant's conduct, and that we can get something that will fix it. Okay. So like we couldn't say, I'm suing you for the car wreck. You have to create a time travel machine, go back and never hit my car. Well, they can't do that, right? So here, the main focus is on this injury in fact. So you suffered an invasion of legally protected interest that's concrete and particularized and actual or imminent, not conjectural or hypothetical. And if you're reading that going, what in the world do all those words mean? That's a fabulous question because the judges don't even know this, okay? They're always fighting over this stuff because it's so, ironically, they talk about concrete in particular. It's so vague, the standard, which is, again, why we always file suit in state court. They remove it to federal court, and then they raise this. The worst thing that happens is we get sent back to state court. But if we file directly in federal court, in our state anyway, if we get kicked out, the statute of limitation might be over to refile in state court. All right, so plaintiff cannot establish constitutional standing based solely on the defendant's bare violation of statute. He can do so by showing it caused some real harm, and very nearly any level of direct injury is sufficient. A concrete injury need only be an identifiable trifle. Don't you love all these words? We got identifiable trifle. We have hypothetical, conjectural, imminent, actual, particularized, concrete. Yeah, it's sort of a bunch of words. So district court said your emotional distress damages and your time trying to figure it out how much you really owed is too insubstantial. And the appellate court says not so. We've explained a plaintiff's wasted time, in particular, can be a concrete injury for standing purposes. So in this case called Pedro, lost time trying to correct inaccuracies in her credit report. That was enough. Okay, that's from 2017. And while we have not yet decided in a published opinion, so remember this opinion is not published, but we haven't decided in a published opinion whether emotional distress alone is sufficiently concrete injury for standing purposes. We have found standing where the plaintiff had emotional distress and wasted time. That's the Loesch case from 2 years ago against Experian. And this was a debt that was discharged, but yet Experian kept reporting it with a balance. And the consumer disputed it wasn't fixed. They sued. And the district court said, you don't have standing. And the 11th Circuit said, whoa. Emotional distress, wasted time, that's enough. So here are the courts saying, we haven't definitively decided whether just wasted time or just emotional distress would be enough. But we do know if you have both, you got standing. So certainly concrete harm from wasted time requires at the very least more than a few seconds. Well, the plaintiff here testified he wasted at least several minutes in connection with each of the collection letters. And he went in person to the association. And he spent time on the telephone. And so we don't have a set amount of time, but it can't just be a second. Let me mention this. I was asked by another state, sort of a group of consumer lawyers in another state, to talk to them about this idea of standing. And this is back in, about July of 20. And I said, look, one thing you do is you sort of slow down time. And here's what I mean. You don't say, plaintiff went to the mailbox or plaintiff got the letter and it was upsetting. Because that seems like it's too close. So you say, plaintiff walked down to the mailbox. Next paragraph. Plaintiff opened the mailbox. Next paragraph. Plaintiff pulled out the letters. Next paragraph. Plaintiff then saw that there was a letter from a collector. Plaintiff's heart began to beat faster, blood pressure, adrenaline. Do I open it? Do I not open it? What do I do? This can't be good news. And then you finally open it. And then you pull it out. And then you read it. And your heart's racing as you're taking time to read it. And so you kind of get the gist, right? We're making it very clear because the courts are looking for all these weird words, right? Concrete, particularized, trifles. Like, what does all that mean? Well, I know if we sort of slow down time and really explain it, that can be helpful, okay? And that's what we seem to see here with this court. So we recognize that time and money spent on the FDCPA lawsuit itself cannot give rise. So in other words, you can't say, well, I don't have standing, but I'm going to bring a lawsuit, and therefore I have standing. But they say initially consulted with the attorney, at least in part to help him accurately calculate his debt. You could substitute in to review his credit reports, to prepare dispute letters, to listen to the voicemail from the debt collector, to read the debt collection letter. Okay, so you sort of have to follow this as a roadmap and obviously be truthful about it and say, well, here's what I did. Or for the lawyers watching this, here's what my client did in this situation. And let's see, time or money spent in defending against a legal action taken by a debt collector against the debtor is separable, so it's different from the cost of bringing the debtor's own lawsuit. Because there's no question that wasted time is a concrete harm, has standing to pursue his claims as long as even a small part is attributable to the defendants. Now, if you take just this, it makes it sound like maybe you don't need emotional distress. That maybe just wasted time in and of itself is enough. And I think that's correct. We go back to the Pedro case, which was a Fair Credit Reporting Act case. And then they say, if the evidence is to be believed, they caused concrete harm before he ever consulted with his lawyer by filing this lien, and it was tangible harm sufficient to give him standing. So here we go. This is kind of the summary. Present evidence he suffered injuries, including an inaccurate claim of lien against his property, time spent trying to determine the correct amount, resolve the lien, avoid the threatened foreclosure, emotional distress manifesting in loss of sleep, which are sufficiently tangible to confer Article 3 standing. And then they say it's traceable. So they don't make it real clear in this because it's not particularly relevant, but we have to have an injury in fact that's traceable, that we can connect to the defendant's conduct. In other words, we couldn't say, well, they put that lien on my house and then my back started hurting because I fell off the roof. Well, that's not related to the lien, okay? So we have to be able to tie it together with the lien. And then we have to have the ability to what's called redressability, which is the ability to get some kind of compensation or resolution. So here we have this injury in fact, okay, this concrete, damage that gives us standing, and then it's fairly traceable, and then a verdict will redress it because you get money damages, so you're taken care of. So they vacate it and remand it. So the take-home lesson from this is think it through very carefully, particularly for the lawyers watching this, as you're pleading this for your client, sort of slow down time so that we can make it very clear, here are all the things that were done. So I heard this many, many years ago on a Tony Robbins tape. So it was literally a cassette tape where he said, people that work out, you say, well, how do you work out? They go, oh, you just go to a gym, you work out. But the people that don't work out, here's what they do. They say, well, I got to go get the clothes together. Then I got to get my shoes. And then I got to put it all together. And then I got to haul all of it out to my car. And then I have to get in my car and put on my seatbelt and shut the door, lock the door, start the car, put it in reverse, back out, look both ways. And then I have to put it in drive. And then I have to drive. And I have 17 traffic lights. And then I have to find a parking spot. And then I have to go around to my car, to the trunk, get the bag out. And then I have to and then I have to lock the car. And then I have to walk in. And then I have to wait to scan my key fob or whatever it is, my card. And then I have to go to the locker room. Then I have to find a locker. And then I have to set my bag down. And then I have to change my clothes. And then I have to and see that you're exhausted, right? You're like, oh my goodness, it's too hard. Of course, the person wants to work out. It's like, oh yeah, you go to the gym, you work out. So we can take that same concept here and really break it down into the smallest little pieces. Like if the plaintiff here, in this case, had said, I spent a lot of time trying to figure this out, I don't know if they would have won. But when they say, well, I hired a lawyer, I hired an accountant, I did some phone calls, I went to the office, I read the letters, I called the condo association, and all these different things, now the court goes, that's enough. You allege standing. So I know this is not the most exciting thing talking about standing, but it is getting to where almost every case we're dealing with this issue. So it's just the reality. Maybe it will change at some point. I'm not real optimistic about that. So if we're going to sort of play in this world, we have to understand standing or we will be gutted in these cases. All right, guys, thanks for watching this. I'll catch you in the next one. Bye-bye.